En afgesproken dat landen elkaar militair zouden beschermen. Inmiddels zijn dat er 32.
Never has a single document with so few words meant so much to so many people. So much security, so much prosperity, and so much peace.
Hello, everybody. We're going to wait for more people to join us. I can see there's now 30 participants. We had quite a lot of registrations. I don't think everybody who registered will join, but still, it's we can wait a couple more minutes. Let's see. Good afternoon, Flaviano.
Good afternoon.
Hi.
We'll just wait for a couple of more minutes and then we can get started. Hi, everyone. Okay, do we have some kind of quorum? Yeah, I think we do. Let me just start, right, Olena? Just shake your head if not. Okay. All right. Hello, everybody, and thank you for joining us for this virtual roundtable entitled First Reactions to the Corporate Sustainability Due Diligence Directive. And thank you for joining us. This event is organized by the law group of Wageningen University in the Netherlands and also by the Rebalance Democracy and Capitalism, which is our Horizon Europe project that we'll tell you a little bit more about in the course of the discussion, perhaps. And the project is a collaboration and under the leadership of Professor Elisa Giuliani, who's one of our speakers today. So my name is Nadia Bernaz. I'm associate professor in the law group in Wageningen University, and I will be chairing this event. So without further ado, I want to introduce our speakers. And in alphabetical order, we first have Flaviano Bianchini, and Flaviano is the founder and executive director of Source International, which is an organization that supports communities in protecting their living environment. Then we have Dr. Claire Bright, who's associate professor of private law, the founder and director of the Nova Center for Business, Human Rights and the Environment at Nova School of Law in Lisbon, Portugal. Then we have Professor Elisa Giuliani, who is professor of management and founder and director of the Responsible Management Research Center, REMARK, at the University of Pisa in Italy. And last but not least, we have Dr. Olena Uvarova, who is associate professor at Yaroslav Mudryi National Law University in Kharkiv, Ukraine, and currently Marie Skłodowska-Curie for Ukraine, postdoctoral researcher at Wageningen University Law Group. So I will be chairing and moderating this event. We have some questions for our speakers, but perhaps before we go into this, I will do a quick recap of where we are with the directive, as perhaps not everyone has been following this in great detail. So I won't go into a lot of detail, but just so that we're all on the same page. So we started, of course, a very long time ago, and we will get into this in this seminar. But just to start with the institutional discussions, we had a commission, the EU Commission proposal for the directive in February 2022. And in fact, we did a seminar very similar to this one when the proposal came out, and Claire was also very nicely a speaker at this event. I will share the link in a minute once I'm not speaking anymore. Then we had, so that was February 2022. Then in December 2022, the EU Council adopted a general approach on the directive. And finally, in June 2023, the European Parliament adopted its position. And once we had all three institutions with something to say about the directive, the trilogue process started and lasted between June and December 2023. The latest development was the adoption by the EU Council in March 2024 of a text, which of course is very different from the original text, and we will discuss that and other issues in this event. At this moment, I believe we expect the European Parliament to adopt the directive on the 24th of April. We're doing this seminar on the assumption that it will go forward, so I hope that we will not be disappointed on this, and we're not, we're not being too quick. But it looks reasonably good, and so we said that we will take the risk. So the text we have, like I said, is very different from previous versions. Perhaps the biggest change that we have, that I'm sure we'll get an opportunity to comment on, is that the original proposal from the Commission talked about a scope. Companies that would be covered by the directive would be companies that have more than 500 employees and an annual turnover of over 150 million euro annual turnover. And now what we have is a text that talks about annual turnover of 450 million euro, which is of course 3 times more than what was originally envisaged. And moreover, the original proposal of the Commission also had special rules for high-risk, so-called high-risk sectors, namely textile, agriculture, and extractive. And for these, for companies in this area, the threshold was even lower. It was put at 250 employees and only 40 million annual turnover. This was scrapped, so we now have 450 million annual turnover. This is the scope of the directive, which, as I understand from discussions on social media, looks like it covers about 5,500 companies in the EU, so a relatively small number. Another change from previous versions is that the due diligence process that companies will have to undertake must cover, of course, their own operations, the operations of their subsidiaries, as well as the operations of business partners in their so-called chain of activities, which is defined in the directive as covering upstream, the upstream chain, and in terms of downstream activities, only distribution, transport, and storage are covered. So maybe some of you can help us make sense of this particular change and what kind of practical consequences that will have. I will finish with one issue, the issue of enforcement and liability, which I'm sure we'll discuss as well. The big, perhaps for me, one of the biggest addition, the biggest, let's say, added value of the directive is the fact that we will now have national authorities empowered to investigate this due diligence practice of companies, so this kind of prevention mechanism, and these national authorities will...
You say you're not feeling it?
Please mute yourself. These national authorities will have the power also to issue penalties. So that's for the enforcement mechanism, and then for liability, which I'm sure we'll talk about as well, we have a fault-based system liability, whereby the liability of companies can be raised in case they have failed in this due diligence process, and this has resulted into a damage. So, in a nutshell, I'm sure there's not much more to say. Of course, this is where we are with the directive. So we're waiting for the European Parliament now to adopt it. So now that I've used all my time to speak and it's 1:10, I can start with the speakers. So I will start with Claire. I want to talk a little bit about the adoption process of the directive, which I briefly covered. So I think you're a great person to start with this because you can talk to us about this. You've been involved from the very start in the European Commission study that they had commissioned back in the days. And so perhaps you can tell us a little bit more about this study. And also, I'm very curious to hear your thoughts about the study that you put together versus the outcome and the directive that we now have. For example, are there any points that were considered super important from the start, and in the end didn't pose any issues, or the other way around, what was considered relatively smooth and in the end became issues that were problematic. So looking forward to hearing from you about that. Thanks, Claire.
Thank you very much, Nadia. Hello, everyone. And thank you to Elena as well for organizing this event and Elisa as well. So I'm very grateful to be here and hoping that indeed we'll have some good news on the 24th of April. Because we've had some last minute changes in the past that had not been expected. So I'm hoping we won't see that again this time. So perhaps to put things back a little bit in context, the study that you referred to, Nadia, the study for the European Commission on due diligence requirements for the supply chains, it was commissioned by the European Commission following the adoption by the Commission of its action plan on financing sustainable growth, and that was back in March 2018. So at the time, the Commission had mentioned the need to carry out analytical and consultative work with relevant stakeholders to assess two things in particular. The first one was the possible need to require corporate boards to develop and disclose a sustainability strategy, which would include due diligence throughout the supply chains, and I'm using here the terminology that was used by the Commission, and also measure sustainable targets. And the second one was a possible need to clarify the rules according to which directors are expected to act in the company's long-term interest. And that led to these two studies, the one on due diligence, which I will focus on, and the one on directors' duties. Now, in our study on due diligence through the supply chains, we looked at the study was organized around four main pillars, which were the ones that the Commission was interested about. So the first one was about market studies. And there, through very wide-scale surveys and interview, we looked at what companies were actually doing, right? At the time in terms of due diligence and human rights and environmental due diligence processes. And what the results and the finding of the study showed is that voluntary approaches and soft law approaches, which were prevalent at the time, were not sufficient because only about 1/3 of companies voluntarily had in place human rights and environmental due diligence processes. And even amongst these 1/3, it was very, very limited. It was limited to first-tier suppliers, etc. So the first main finding is we need to go beyond soft law, beyond voluntary approaches, because that is simply not enough. Then in the second pillar of the study, we looked at the regulatory, we did a regulatory review. So we looked at what already existed, and in particular, looking at the growing number of laws that had been adopted, which either sought to encourage or require companies to exercise due diligence. So we looked at the laws that imposed reporting requirements, like the one in California, in the UK and in Australia in terms of modern slavery, also more general ones at the EU level. And then we looked at due diligence laws, the ones that were sector-specific or issue-specific, like the EU Timber Regulation, the Conflict Minerals one, or the Dutch Child Labour Due Diligence Act, and the one that were more overarching. At the time, we only had the French law. Now we have the German one, and the Norwegian one. So that analysis allowed us to look at how these laws were also implemented in practice. What were their strengths and what were their weaknesses. And on the basis of that, we identified regulatory models at the EU level with 4 regulatory options, starting from the baseline scenario, no policy change. This was necessary for the economic impact assessment part of the study, to introducing new voluntary guidelines, new reporting requirements that were indeed, in fact, adopted later on by the CSRD, and legislation that would actually require companies to exercise human rights and environmental due diligence. There with various sub-options in terms of the size of the companies that would be included, the type of enforcement mechanisms, etc. And we then presented these various options to the various stakeholder groups to gather their opinion. And so what we saw was that there was an overwhelming majority that was supporting the adoption of the last option, so an overarching legislation that would require companies to exercise human rights and environmental due diligence. So in that sense, the directive is aligned to that finding of the study. However, one thing I think is worth mentioning is, I mentioned there was an overwhelming majority of stakeholders in favor. There was one stakeholder group that was not in favor of that. You might not be surprised to hear that was business organizations. And of course, these were the ones that were the most destructive at the last minute, but also throughout the process. And that led to the difficulties we had toward the adoption of the directive. So it's quite interesting because we noticed in that study that often business organizations were not even aligned with their member companies. So when we spoke to the member companies, they would say, we actually are in favor of legislation. And in fact, I'll recall that in the study, we found that 70% of businesses found that mandatory human rights and due diligence legislation would be beneficial to them because it would level the playing field, provide greater legal certainty, and have one uniformed standard at the European level rather than a patchwork of laws. So we saw that individual companies were generally in favor of the laws, business associations not so much, even if that was not aligned with the positions of their individual member companies. One point that came back consistently was in our exchanges with stakeholders was the importance to align the directive with existing international standards. And I'm thinking in particular of the UN guiding principles and the OECD guidelines. And I think this is really where, this is really the key point here. So insofar as the Corporate Sustainability Due Diligence Directive is aligned with international standards, then it is also, I would say, aligned with the findings of the study. Where there might be differences is where it might be less aligned. To me, what will make a difference will be the practice, how it is operationalized. And we can come back on this later, so I won't develop too much here, but to see whether companies actually engage in meaningful due diligence, or whether we see, like we have seen in some countries, in some of the practices of companies in some countries that already have mandatory due diligence laws, like in France, etc., an approach that is more narrow, compliance-orientated, ticks-the-box approach, because that would not then be in line with international standards. So I think the sort of answer to your question, Nadia, is going to be more in the interpretation rather than in the text itself. The text has, I would say, the main key elements that are in the international standards in terms of the various steps of the due diligence processes. Importantly, the final version of the text does have a dedicated article on meaningful stakeholder engagements, and that's absolutely key in line with international standards, but also it's key if we look at the practice of companies in countries that already have done mandatory due diligence laws, and I'm thinking again of France, where in particular the study for the French government and the implementation of the law showed that the lack of stakeholder engagement was actually one of the main pitfalls of the law. So I think this is where hopefully we might be able to see progress, and perhaps I will stop here for now.
Thank you very much, Claire, for this very clear start. Still on the, I'm sure we'll come back to some of the points as well, also in the questions, but just to start going around and give the floor also to the other speakers. We've talked already about this very long and also unfinished saga around the adoption of the directive. I wonder, what are your thoughts about this? Maybe going in the order in which I'm seeing you on my screen at this moment. Maybe Elisa, do you wanna start about your thoughts about this adoption process and where we are now?
So hi everyone. Thank you for having me, Nadia and Olena. To me, it's an important step ahead. It's an important step that has been made. It's very late. I mean, if I have to think, even before 2018, as Claire was mentioning, the draft norms and all this, the process that at the UN level have been started back in the 90s, if not earlier, then of course we are coming kind of late, especially because in the last 20 years we have seen globalization going like crazy, and we have experienced a lot of abuses worldwide. So clearly we are arriving there. We are arriving very late, and that's to me that's clearly an issue. It's curious is that, at least in my country and in my experience, when talking to both policymakers and the business sector, both large and small, for many years, I always find a very high level of ignorance about business and human rights, and especially about this directive being prepared. A lot of top managers, including CEOs of international companies I've talked to, they had no idea about this. Business associations, at least in my country, have overtly avoided talking about the topic. I'm not surprised that they have been, according to what I've read, even one of the first opponents, and for which we had the troubles at the council recently. So clearly they have literally overlooked this issue. And one of the consistent replies I get from the industry, which is of course no excuse and it's unacceptable, is that, well, if the Chinese do that, if we don't, use abusing of human rights as a source of income, as a source of profits, we're gonna, lose terrain in the international and in global competition, which is of course a dystopian, wrong view from a manager, because managers are supposed to create economic value for the long run. And also, I think there is a mismatch between what we study. The literature, the management literature has made a lot of progress in understanding the role of companies in society. And yet the people that are on the market right now have like their views. It's really a 1970s views. So there is really a temporal, diachronic problem between what is the frontier of knowledge and the frontier of practice, and what is the real practice in the market, even in high income economies. There's such a huge gap, and so really the directive is going to raise awareness. It's not going to, as I will probably elaborate later, is not going to really make it has to be accompanied by a change in the framing of the cognitive frames of managers themselves. A lot of the managers and CEOs and top managers in the market now have been trained the old way. They have been trained in a very shareholder maximization framework, 1970s type of approach, and they have had just a little updates on that approach. Perhaps, CSR kind of nice things to have, but not a real transformation of an understanding of how the business should be run without undermining human rights and without, irreversibly damaging the environment. This is something they have not fully understood how to do that. So that's a practical issues we will have to face beyond And when I talk this to it's important, and then I will conclude here and leave the others speak, but it's important to remind that these things are being now increasingly more taught in business schools. So perhaps this cohort of students will be much more familiar with these notions and will understand the business in a different way. So when I talk to my students and say, well, you're still using, and most of the textbooks sometimes are still using shareholder value maximization approaches, and I said they are completely outdated because since the 70s, the world had changed dramatically. So I asked them, would you use an iPhone or whatever, it's a mobile phone from the 70s? No, you wouldn't. I mean, it would be too slow. It would be useless for you. But then why do you use theories of that ages when economics is a social science and we need to change, history matters, and so on. So clearly we are outdated in the practice. And so this catch up is really much needed. So I'm not sure the due diligence directive will allow for a full catch up, but certainly it's a first step, and it's absolutely fundamental that it's done.
Well, thank you for this message of hope, Elisa. Yes, let's. I think we'll come back also to some of the issues you've mentioned. I'm still going around, looking at who's next on my screen. Maybe Flaviano, would you like to say a few words about this adoption and what you think is its significance or maybe insignificance? What do you think?
Well, first of all, good afternoon, everyone, and thank you for hosting me. I had to clarify that I spent the last almost 20 years, basically my entire career on the other side, on the other spectrum of what we're talking. So not dealing with companies, but with affected communities. So I have a very different point of view from those aspects. And I remember when I started, it was 20 years ago, that we were already talking about this issue of due diligence and, the OECD guidelines and all of these things, the Ruggie principles and all these things. And in the past 20 years, what I've seen, again, not from the side of companies or corporations, but from the side of affected communities, is that nothing has changed actually. And, and I have seen, and I have done, bring court cases of companies that had all the perfect tick the box exercise of OECD guidelines done perfectly. And you go to the webpage and it looks like they're the best company on earth, and then destroying an entire community with mining or oil extractions in South America or Africa or Asia, or they're down the line of their supply chain or even directly. So, and when you see, and we can look at past cases similar, when you see that something takes so long, it's a bit like dragging forever. When you drag something for 30 years, it means that at the end of the day, you ended up with something that is a surrogate of what you start. That's basically, otherwise you wouldn't drag it for 30 years. And we will go into the details later, but so focusing on what are the good aspects and the bad aspects of this directive. But generally, if we analyze the fact that it took 30 years, what I've seen is that 30 years, they gained 30 years of time, and nothing has basically changed for the affected communities down the line.
Yeah, thank you for this. Thank you for your perspective. I will push you a little bit more on that in the next phase also of the event. But this is, of course, needs to be said. I think this is important context. Olena, would you like to say a few words about this adoption and its significance?
Yeah, thank you very much, and thank you to all our participants.
Oh, we lost you.
Are you hearing me? No?
Yes, now we
Yes?
can.
Okay, thank you. So no, actually I have a mix of feelings about this saga, as Nadia said. On one hand, I agree with Elisa, it comes extremely late. However, on the other hand, the European Union, by adopting this directive, is setting a leading example still, and it is late, but it's still the first. And I hope that it will have a positive and transformative impact. And also, I should say that probably it's a characteristic of all human rights developments, because at the end of the day, Universal Human Rights Declaration was also late, and the directive and the entire political process surrounding it are interesting for me from multiple perspectives. They contribute to the ongoing discourse regarding the smart mix of voluntary and mandatory measures that Claire discovered very well, and also the finding balance between soft and hard regulation. And actually, I should say, because I'm working a lot in Eastern Europe, non-EU countries in Eastern Europe and in Central Asia, it's a big question for them now, what way should be taken, and I should say that the political will now is going in favor of soft measures because of many issues, and because of this compromise with businesses, and because of very complicated economic situation. So it's a lot of factors, but this discourse beyond the European Union has a little bit other tendency still. And additionally, we also see that this directive is a part of much more broader discussion about transition to responsible economic order, and what Lisa said, and what many others, our colleagues, are talking about, and what I love very much the reports of Surya Deva as a special rapporteur for the right to development, and he is mentioning a lot what we need to have this real transformation. So yeah, but also this political process shows that this transformation is a very complicated task, particularly in the lead up to the elections. I think that all what we had during last 2 months mostly because we are going to the European elections, and it had impact as well. And also, I should say that I like very much that this process showed the importance of civil society and academic community engagement in different stages of this process, starting from this study where Claire participated significantly, and also during this, again, last 2 months. I haven't seen so strong advocacy campaign by civil society and academic community, by young researchers. So it was really something amazing for me. And also, I should say that it's also about political power of businesses. And what we hope to have and what we have in final, there is a huge difference, but also, it shows what impact business could have. But also, for me, it shows what Elisa said, that there are a lot of myths around this directive, and probably, no, you know, these myths are based on the lack of knowledge, on the lack of awareness, and it's a common problem for all regions. Yeah, and we again see this compromise. John Ruggie made the compromise 13 years ago. Now we see this compromise with the Corporate Sustainability Due Diligence Directive, but you should agree that there is a very different compromise. So we see the progress, right? And also, I should say that, yeah, businesses are very different, and businesses have very different view on these processes. And just a very small example, the provisions about living wage that we have now in the directive, they came from corporate practices, and some companies started to practice to introduce living wage to their supply chains, and now we have this provision in the directive. And finally, on a personal note, this entire saga is also, for me, is also about women political leadership. Many people were involved in this process, but Lara Walters and Heidi Hautala, they are exceptional for me.
Right, thank you for this. True, I agree with that. I think it also shows the importance of personal leadership, right? Because at the end of the day, institutions move when there is leadership to move it, and it's clear they went above and beyond to make this happen. And without them, probably we wouldn't be there. Perhaps there are articles to be written on this process to look at this a little further. Okay, so I want to move to a different point, perhaps a more practical point about the significance of the directive for, let's say, the business and human rights and corporate accountability field. And I want to start with Flaviano. I wonder, I mean, you've been very clear about the lack of progress and how, in your opinion, but also more importantly, based on your experience, that basically very little, if anything, has changed on the ground for affected communities that you work with. I wonder if there's anything for you, in your opinion, with the adoption of this directive. Is there anything, any leverage, any use that you see for this text in your work, in your advocacy work, that you can use this text as a hook for something else? Perhaps not in the way it's intended to work, but does that create a space? Do you think that creates a space for your work that perhaps didn't exist before? And if not, why not? And what else would be needed, in your opinion, then, if it's not that?
Well, I think there is some good aspect and bad. The bad aspect is, as was mentioned before by Claire, was the number of companies that are involved, or maybe by you, actually, were you that were mentioning the change in the directive. So the Commission considered at the beginning that it would have affect 1% of the companies of the EU. With the new change now, apparently, based on our research made by SOMO in the Netherlands, it affects less than 0.05% of the companies. So very, very little companies. And on the other end, as was mentioned before, I mean, again, based on my experience, I don't believe that much in self-reporting and self-control. Actually, I don't believe it at all, to be honest. We have an expression in Italy that is, ask to the bartender if the wine is good, which is basically how the self-reporting it is, you know? I mean, why should I tell you that I'm violating human rights when I'm violating human rights? I mean, that's pretty obvious. So on this side, I think the new directive with the new control entity is doing something in the right direction. And another thing that I think that might be useful in the advocacy role is the supply chain aspect. Again, an estimation from the Commission, from the European Commission, stated that 80 to 90% of the impact is made outside the EU by the supply chain of EU companies. So, and this is like a clear example. If you take, I don't know, a computer assembled in Europe, the microchip is made in Taiwan, and probably the minerals are assembled in China and extracted somewhere in Africa and South America. So it's very easy to understand that the real impact is down the line. So what I think it's good now for, especially for advocacy and also maybe for legal aspects, is the fact that you can basically trace the company for the responsibility of their entire supply chain. Now, I can also see a lot of easy way to escape from companies if it's not properly drafted, because, you know, I'm a computer manufacturer in Europe, I buy my chip in China. How can I really control where the cobalt came from, or batteries, where the lithium came from? Lithium is obviously a metal, as every other metal is melted together. You will never have a lithium coming from one mine. The lithium comes from different mine, go to a smelter, then it's melted together, and then it transforms into a microchip. So it's very complicated. Or thinking about food, how can you really, I mean, you can trace the olive oil that you buy from your supplier, but you cannot trace all the oils that are inside a final product that contain 4 different oils from 3 different origin each. So this is, I think, it's the good aspect of the new regulation, the supply chain. Now we don't know how it will be drafted in details and all the regulations. I think there is where we can see, I can see, at least for the advocacy and legal work, I can see there a huge leverage, a huge increase in possibilities if it is properly drafted. On the other hand, I can see that if it's not properly written and very clear managed, I can see a lot of easy escape from companies.
Yeah, thank you for this point. So to move on also, I want to ask Elisa, what do you think about the significance of this adoption? Let's say from, I know you probably don't want me to say that, but let's say from the business side and from a management perspective, what changes can we expect to occur in corporate practice, and when? I mean, you've been clear in saying that you think there's a long way to go for many companies and lack of awareness and sort of 1970s mindset. So presumably changes will have to happen, at least in some of these companies. So what changes do you expect to occur? And I'm also interested to hear your views, if any, about the fact that the high-risk sector, the special rules for high-risk sectors were dropped. I know you had conducted some research about which companies are perhaps more likely to abuse human rights and why. And so I wonder if you have already some thoughts about the fact that the high-risk sectors were dropped. Does that make a difference in your view, or was that perhaps impractical? I've heard that as well, that some said it will just be too complicated to implement. So what do you think about that?
Well, thank you again very much for asking me this. Let's say that I can bring a little bit of good news from earlier research that we have conducted together with different colleagues, Federica Agnari among others, who basically we have tried to look at across industries and over time through quantitative studies to see whether regulations matter in reducing the probability of human rights misbehavior by the largest companies worldwide. And we do, I have to say, I mean, just to put the long story brief, but we do have some encouraging results about the fact that norms, legally binding norms in particular, but also sometimes and in given circumstances also soft norms and especially voluntary initiatives work to self-regulate, especially to reduce the probability that companies abuse the worst forms of human rights. So of course, this contrasts starkly with the evidence that Fabiano was pointing to before. But you know, if we have to look like a very macro level picture, then we do see the importance of norm in reducing, at least, or curbing the probability of human rights misbehavior. And this is valid across time, across space, and across industries. So that's why we need this kind of regulation. So regulations, I mean, the regulations I've been talking about are not specific on human rights. They're more like general systems of the enforcement of the rule of law, or similar or specific areas like human, like speech and press freedom. So this, when there are strong norms regulating and monitoring behavior of companies, companies tend to respond to that. So that's good, and that's promising for the due diligence laws. That said, of course, we also observe that there is a huge heterogeneity across firms. And so some firms will certainly construe the due diligence directive as a legal exercise, so will be just confined within the legal department or the CSR department, and they will do all the nice things that are not transformative at all and leave the business, at least for the short run, completely untouched. And so that's where clearly the due diligence like to be failing. But I think it can also be, you know, a push for thinking through a little bit with more depth about how to really implement and to, you know, this due diligence in practice, because if they have to minimize harm, they have to avoid harm, they have to engage with supply chain actors, they have to provide support to small and medium enterprises in the value chain, they have to provide remedy. So there is a lot of items in the norm that in the due diligence directive that ask for more than just a set of policies. And so perhaps there is where they could mobilize some resources within the firm. Certainly, this has to be accompanied with a transformation of the business model. So they have to shift from the current irresponsible business models, as sometimes we call them in the literature, or corporate irresponsibility, to a more responsible models where actually firms are able to create economic value by incorporating the costs in their production functions of a responsible business conduct. So said in other terms, they should not create economic externalities or negative externalities then you know, remain to society or to governments to fix, but they need to take responsibility for that. And, you know, there are several models, there are several examples of companies that can, you know, have succeeded in this direction. And I think these are the models that we should try to teach more in the university and to discuss more with the business sector, because there are different ways, there are alternative ways of doing business. And so clearly this is where the role model should start playing an important role. We have been discussing also in the management literature about the fact of abandoning narrow-minded cost-benefit analysis when dealing with sustainability and human rights and environmental issues, and embracing a more paradoxical cognitive frames, which means that sometimes managers have to accept that fixing sustainability problems is not easy, requires time, and especially sometimes it may imply to sacrifice short-term gains over a longer-term gains in different areas, not just economic, but also societal and environmental. So we really need to transform the way we see business. And this process is ongoing, and it's going in parallel to the due diligence movement, okay? The other thing that I think is promising here is that, first of all, I would like to really see how, you know, how companies will support SMEs, because one of the problems is for SMEs to be able to comply with the higher standards. Certainly the fact that it's made explicit that they have to provide capacity building, financing, different forms of financing for them. It's important because clearly this is where SMEs struggle. They are pressed by price competition. They have to comply with higher standards, and of course they cannot. There is where you have difficulties in profitability, which is a problem that the largest companies don't have. So clearly this is a critical area that, depending on how it's operationalized by companies, can also be bringing some positive outcomes. And the last thing I wanted to point out here is that I think that this due diligence directive and similar laws, when they gain legitimacy internationally, so they become accepted, they are a fact, then I think they are helpful for trying to bring them to other domains of policy, of economic policies. So for instance, what I've been trying to do in the last couple of years is to try and use these kind of initiatives to be incorporated within industrial policies. So asking policymakers whether we can think about conditionalities that incorporate social, environmental criteria for companies to get financial backup by the government through industrial policies, which is currently not done. Okay, there are some conditionalities, but not certainly regarding human rights and the environment. And so clearly this is an area of policy development that is very interesting, and this kind of directive can yield greater legitimacy to this kind of policies. And I think there was a question on the public procurement. Again, this is also one way in which you can strengthen and you can give teeth to this kind of initiatives, because then when the government give support to companies and you have to meet certain criteria, then of course you create an incentive for companies to transform their business model. Of course, this is hard to operationalize in a certain way, but I leave it for discussion or for another time, because this is clearly difficult to know how to do that. But I think it's a key topic.
Thank you, Elisa. I just have a quick follow-up question for you before I move on to the other speakers. You mentioned that some realization within let's say management research around the importance of these issues, and some literature that looks at that perhaps looks a bit more at due diligence. I wonder, what is your, of course this is a personal assessment, like maybe not based on science, but what's your view about how these issues have entered the management literature? Because I'll tell you why I'm asking this, is because I have this feeling that us, among, let's say, the law people, there's been, of course, lots of discussions, and the business and human rights people have been all over the due diligence discussions. But then I end up reviewing for business journals, and I feel that the gap, let's say, is very important, that in these circles the discussions or the important issues are elsewhere, for example on reporting, as opposed to due diligence. I wonder if I've just been unlucky with the kind of pieces I've received, or whether you would say that in the management literature, this sort of due diligence, I'm going to say revolution, though I mean I'm using it with caution, but this whole idea, this whole change of mindset that we're hoping this will prompt, I mean, is it there in the literature, you would say, or just not yet, or not at all?
Well, certainly there is, in some areas, there is something being written. I think it's a lot of the management literature has, not entirely, but one part of it has a quantitative flavor. It wants to test theories. And so the due diligence law is too, in different countries, it's too recent to see anything meaningful. So we need more time and more years to really have for instance, there are studies that are interesting on the U.S. conflict mineral related legislations to see how this affected transparency and what companies were communicating and so on. But for the due diligence, it's very recent to see anything meaningful in terms of assessing an impact of that particular policy. So that may constrain the interest. There are, I would say it's a growing topic, but it's still rather niche. We of course, there's some literature on business and human rights, of course, but it's not well, one of the issues I think is that sometimes the debate on norms, on social and environmental norms is huge. So there's a huge literature that, and so conceptually, maybe they just see it's just another one of those norms. So they don't expect this conceptually and theoretically wise to be so much transformative or different from what we know from other norms. So that's perhaps also the limitation sometimes in bringing this is, without data and conceptually is not necessarily going to be that transformative, or it's not perceived as particularly different from other kinds of normative interventions. So that might limit the interest so far. Besides, it's not very, a lot of the management literature is not very normative per se. It's more like theory testing or, and so maybe that's the data part is hard in this kind of area. In fact, this is what we've experienced. Collecting data on human rights, business and human rights is very, very heavy and difficult and long. And so you don't have readily available databases for that in most of the cases.
Yeah, no, that's an interesting perspective for sure. So let's talk about law and the significance of the adoption of the directive. Again, jumping a little bit ahead here, but assuming this is going to happen, how would you say, perhaps starting with Claire, who has for a while, what is the significance of this for legal research, for lawyers? Do you see the legal community adequately preparing for upcoming changes? What needs to happen?
Thank you for the question. If you allow me, just before answering that question, I wanted to come back on something that Flaviana said about having 0.05% of the companies that will be covered directly by the directive, and also linked to what Elisa was just saying in relation to SMEs as well. And I just wanted to reshare again here one of the findings of the economic impact assessment part of our study, which was done by economists, not by myself, which actually found that the cost of mandatory due diligence compared to the revenue of companies was quite low, and that in fact it would amount to less than 0.14% for even for SMEs, and 0.009% for large companies. So when we see all the debates that have been sort of slowing down the process of the adoption of the directive, and especially around SMEs won't be able to cope with that, actually numbers by economists show that it's not true at all. Yet, what reassures me is, as we know, and as Elisa was also reminding us, SMEs are indirectly impacted by the directive, and we have seen that again if we see the example after a number of years of application of the French law. We have seen that, for instance, French SMEs that supply larger companies in scope have been asked. In fact, there was a study by PwC that showed that 80% of French SMEs supplying larger companies in scope of the French law had been asked to put in place certain human rights and environmental due diligence processes by these larger companies. The problem was that they were not accompanied either financially or otherwise. And so that's where I also agree Elisa, and reminding us that the directive does have some specific provisions on that to require the support of SME. Then we'll see how it's actually implemented in practice, but I think that's really important. And the directive also requires larger companies to look into their own purchasing practices and how these might have also played a role and contributed to the adverse impacts. And I think that's really important too. Now moving to your question on the roles of lawyers and the implications for lawyers and legal research, I think it's absolutely huge. My main worry, and I'll be very transparent here, is we have already seen there are different types of legal advice that is being offered. And there is a type of lawyer that will offer the legal advice as a very tick box exercise, let's protect yourself from the risks, etc. In fact, we've seen that after the Vedanta case, and I actually took a screenshot and I show it to my students every time we have a class on that. One of the big law firms publishing advice post-Vedanta actually advising companies to disengage with their subsidiaries as much as possible so that they wouldn't be held liable following the ruling. This was actually published on a website of a big law firm. That worries me a lot because what some lawyers might do is give this kind of very wrong advice but not helpful at all for improving things on the ground, and actually not helpful at all to their clients that would then face issues of liability if they're not doing it properly. So there is a need to raise awareness, but also to do capacity building, I would say, around, again, what meaningful due diligence aligned with international standards mean, rather than, let's sort of get the companies not to face any legal risks and sort of adopt a compliance, very narrow compliance focused approach. Another thing that we have seen in practice in various countries, having already laws of the types, or even the ones that do not, is that when the legal departments are in charge, the legal departments within companies are in charge of applying and ensuring the monitoring of the due diligence processes, it tends to be in a very, again, risk avoidance approach. What we do see as well is that departments involved tend to work in silo, whereas what is needed is an integrated approach and a holistic approach. So there is a need here to raise awareness around this, because a meaningful due diligence process necessarily have this integrative approach of all the departments that are relevant, and not just from the legal one or the sustainability one, or whatever the name might be. Another point that I think is important here is also the need to train judges. Here, of course, we have now a directive with a civil liability provisions that will need to be applied in practice. And the role of judges is really key here. We see it again with the example of France. With the example of the French due diligence law, it's even greater, because the French due diligence law does not have a public authority that helps clarifying the law, unlike the German one, for instance. And so the role of the judge is key in interpreting the law. And we've seen in the various cases that we've had in France that there were some confusions that led to delays in the cases. Yet the judges can have a really important role. And in France, we had the first case on the merits, which was the case against La Poste, where the French courts made some very important points onto how, for instance, the risk mapping, the sort of detail of the risk mapping, what should that include, about the accuracy of the prioritization of the risks, about the evaluation of the mitigation efforts, etc. And that really helps in the interpretation of the law, but also in the operationalization of the law. Nonetheless, there are few judges that are experts in that field, and of course it makes sense because it's a relatively new field. So I think there is a lot of importance of the training here that will be key to sort of a good and helpful implementation of the law. Maybe I'll stop here for now.
Yeah, thank you for this. I think this is a really important point that, of course, having hard law means that lawyers will be more involved, and that's a double-edged sword, because the tendency to view this and to protect the company at all costs. I mean, this is what they're paid to do, right? And this is how they succeed. And is that a 1970s mindset? I don't know, but this is what they do. This is the job, to prevent lawsuits. And so I think we're going to have very interesting discussions ahead, also with the national authorities. I'm irresponsibly excited about these national authorities. I think this is for the first time we'll have to see how it's implemented, of course. But I think this is a big step, because otherwise this job is done by NGOs. This job is, we've seen it in the French law, in the Modern Slavery Act. If it wasn't for NGOs stepping up and actually creating lists even of companies that fall within the rules, there would be very little knowledge about what's happening. So I think this is interesting. We'll have interesting discussions. To come back to the cases, there's I remember this case against Total, where to understand the mismatch, right? This case against Total in France, where the lawyers of Total said, well, this is not a case about human rights of communities. This is a case about our vigilance plan. And I think, yes, right. But of course, for us in the human rights field, this is of course about communities. It's not about the plan. But this sort of mismatches, I think we'll see a lot of that moving forward. Hopefully, that will be accompanied by a change of mindset. But this is definitely, I think, once you put the lawyers in charge of this, there could be some unintended consequences happening. I wanted to give the floor to Olena, but I see Flaviano. Did you want to jump in? Is that directly related to what we were talking about?
Yes, a little bit.
Then please, yeah.
I mean, about the aspect of the national authority, which is, of course, also, I mean, myself, before I have underlined how it is a positive thing, but it is not clear how these will affect on the supply chain when the national authorities is on another nation. So if the national authority of France or Germany might be very effective, I'm wondering how these will apply when the cobalt is extracted in Congo, for example, or the textile manufacture is done in Bangladesh, or, so, I mean, it is obviously a good step ahead. It's better than nothing, but still, I think in this hyper globalized world and this very globalized supply chain, I think we do need something more than a national authority that will control only the final part of the process.
Yeah, I mean, there's clearly issues about the powers that they will have, the reach, whether they'll be able to ask for documents to be disclosed, and if so, where. All sorts of. I think we're not finished with this discussion for sure, and we have to wait for transposition as well. Countries will have leeway in that. I think in terms of advocacy, there will be some work to be done in individual EU countries around what this national authority will look like, whether they'll have proper budget, and all of that. So this is just the beginning, I would say, and that's one of the issues for sure. What exactly will they be able to do? Olena, did you want to add anything about the significance for, let's say, the legal field? talking to you now with your hat of co-president of the Global Business and Human Rights Scholars Association, so you know a thing or two about business and human rights and legal research. What do you think?
Yeah,
do you see this
yeah.
as a big thing? Yeah.
Thank you for this question. I should say that actually our participants today are also mostly from academia. It's 55% of participants are from academia. So I think that there is an understanding the scope of research issues and research questions that could be raised based on the Corporate Sustainability Due Diligence Directive. But actually, what I'm also thinking about, it's not a new idea, but I think that corporate sustainability due diligence raises this question again, that we are not talking about just about corporate sustainability due diligence directive. We need to, to have again more holistic approach and to understand general principles on corporate sustainability or on business and human rights, how we call this area. And when, for example, Claire was saying about that it will be a huge significance of interpretation and judges should play a crucial role, I think it also returns us to the question, through what lenses, based on what general principles we will interpret these provisions, because it should not be just normativistic or positivistic approach. So it's not a new discussion, and of course I think that each of us will sit alone and think about what actually are general principles of business and human rights. I believe we will phrase them, but still I have a feeling that it's not so well developed as, for example, in civil law or in criminal law or in constitutional law, when it's very basic things to know general principles of this field of law. So I think that we need to pay also more attention to this, I would say, general understanding of our law field. And also as for education of lawyers, it's also a big discussion, and of course I can refer to the Business and Human Rights Teaching Forum, and they are doing a lot in this field, and I mean that I have a feeling that we need to have more discussions with our colleagues from other field of law, and try to incorporate business and human rights. And I agree with Elisa that this directive could be a hook to incorporate corporate sustainability approach to other fields of legal and non-legal knowledge, because we can conduct millions of summer schools on business and human rights, and even to have courses on business and human rights, but when our students come to civil law courses and our colleagues are not aware with business and human rights approach, it doesn't work. So we need to have a more multidisciplinary discussions, I would say. Yeah.
Thank you for this, Olena. I will continue with you to move on to the third and final point I have on my list, and then we'll move on to the Q&A. I think there was some questions already. But I want to talk a little bit about the significance of the directive beyond the European Union. This is something that, you know, as an international law person at heart, I'm mostly interested in. So I want to ask you, Olena, what does that mean for you? What is the significance of this beyond the EU? I know there was some talks from the Ukrainian on the Ukrainian side that they actually weighed in on the adoption of the directive. And also, I know something dear to your heart, the concept of heightened human rights due diligence made its way in the preamble of the directive. So I wonder if you could also reflect on that.
Yeah, thank you for this question. I will be brief because of timing. But no, I should say that actually it's very important political message for countries beyond the European Union, especially those countries who are trying to integrate in European political or economical sphere. So for just for example, in Ukraine, we already have scheduled 2 online events on Corporate Sustainability Due Diligence Directive just in April, and one of this event was initiated by one of the biggest business association in Ukraine. Another one should be in cooperation with the Ministry of Economy of Ukraine. No, so there is an interest, and it's really important change, in attitude related to these questions, because in many countries in my region, European developments in this sphere are taken seriously, and it's important. And also I should say that, for example, at the stage when there was a discussion to vote or not vote for the directive, the first Vice Prime Minister of Ukraine posted the message that it's important for Ukraine in the context of reconstruction because recovery of Ukraine is based on the involvement of private sector, and it's important for Ukraine that this involvement should be responsible. So it's one of the guarantees that companies which will be involved will conduct responsibly and will ensure that their supply chains will conduct responsibly as well. And also in Central Asia, a lot of attention, were attracted to this process. So I should say that, it's important sign beyond the European Union on political will perspective. No, of course, there are a lot of other factors there. As about heightened human rights due diligence, again, it's about importance of civil society organizations because, the text of the directive when it was published on 23rd or 23rd of 2022, one day before the war in Ukraine started, this text didn't include heightened human rights due diligence, but then 51 civil society organizations raised this question, and now we have heightened human rights due diligence concept in the text. Nadia knows that for me it's a little bit narrow approach because it's focused on international humanitarian law, which is important, but it's not enough because, and actually it also refers to guidance prepared by UNDP and you know, I like I love the team of authors of these guidelines. They did amazing job, but even they mentioned in the guidelines that in the case when we have the war, when one state is aggressor and another state defends itself, it's a huge difference from other types of conflicts, and that's why we need to have more. The situation is much more complicated than if we just will understand heightened human rights diligence as assessment of the impact of companies on the conflict, because also conflict impacts human rights, and the companies should operate in the context when human rights are impacted by the conflict.
Thank you for this message. So I'm going through my list. Perhaps Claire, do you want to add something about the significance of the directive beyond the EU? Do you have some more to say about that?
Sure, I'll just say a few words. The importance of the directive beyond the EU is huge, is both direct, because or sort of third country companies, as they call them, are in the direct scope of the directive, as we know, some of them at least. It's also indirect insofar as they are within the value chains of European companies in scope. And Flaviano was reminding us earlier about the percentage, right, of adverse human rights impact that are originating from these supply chains, so they are very important. We have seen in practice companies getting ready for them. Last year, I delivered trainings in Mozambique and in Tunisia, coordinated by the UN Development Program, because companies are getting ready for it. They know they're already being requested by their European buyers to put in place certain due diligence processes, and they know that this is only going to increase. They see it as a competitive advantage. I remember when speaking with companies in Tunisia and the governments there, they want to be sort of prepared so that they are the chosen suppliers that remain, but they also maybe gain new markets and new contracts, because they feel that if they are more prepared than, let's say, their American or Algerian counterparts, then companies in scope are more likely to choose them as business partners and as suppliers. So we do see already the implications of the directive even before it has been actually adopted and implemented, and it will only just grow. And maybe I'll leave the floor to my colleagues.
Yeah, thank you for this. This is really important and encouraging, I would say. Flaviano, do you want to say a word about the significance beyond the EU? I've already asked about your work, but perhaps some additional thoughts on this? Flaviano? Yeah.
Sorry, I didn't understand if you asked it to me or
Yes,
didn't get the name.
that was for you.
Yes, again, I do think this is the most positive thing that I can get from the directive, and it's hard to say now. I mean, again, we have to see how this will develop in the next few months or probably even a couple of years. But I think that the best thing of this directive is actually that goes somehow beyond the EU. Because at the end of the day, I mean, as mentioned before, I mean, the majority of the impact, the gross impact, not saying that there are no impact in the EU, but the majority and the most severe cases are outside the EU. And I think that the EU should be the lead in addressing the problem worldwide and not only in the EU. Otherwise, we go back to what Professor Giuliani was saying when she was saying that the EU companies are afraid to lose against China. You will always lose against China. I mean, you have to differentiate from China, and this, I think, it's the way to do it. Because if you try to compete with China on lowering the cost or things like that, it's like me trying to outrun Usain Bolt. I'm a decent runner, but that's a bit too much. So I think the EU should be the lead of a new, different way of doing business, and therefore I think this is actually the key aspect of the directive.
Yeah, thank you for this. I want to end this first part of the roundtable with giving the floor to Elisa about the significance of the directive beyond the EU. What are your thoughts about that?
Sure. Yeah. Well, I agree with what my colleagues before have mentioned. Let me just say, pick up the China thing. As I mentioned before, a lot of the top managers I talked to say, well, we'll be outcompeted by China. And that's a kind of ironic comment, because clearly we have been outcompeted by China on manufacturing, progressively and against all expectations, at least in the past. We have been steadily but consistently being outcompeted on many technologies and technological development. Now, I mean, we could be easily outcompeted on being able to run a business responsibly. So if we just wait long enough, they will be able to outcompete us on this too. So I really don't understand this perspective. It's clear that we have to take this as an opportunity, that this is certainly a way to rethink the way companies manage their value chains in different countries, because clearly their business is based on other countries' extractive and manufacturing activities beyond the EU. And the sooner they rewire, they reorganize their business model and are able to create value, economic value, without undermining rights, the sooner they will be successful on the market and they will be able to outcompete the others. So I don't really see how we can avoid this. And certainly this is going to be a good thing for Europe, but also a good thing for other countries. And I don't think that waiting just because other countries are lagging behind. And as Claire was saying, I mean, they're already getting organized for this. So yeah, I mean, it's really ironic the way we sometimes think and see things in perspective in the wrong way.
Yeah, thank you for this. We're actually on time. Incredible. So we still have quite some time in this meeting. I would like to open the floor to questions. Ideally, you would unmute yourself, introduce yourself very briefly, and ask the question. If you're too shy to do this, it's also okay to type the question in the chat, but I would prefer if you speak. I see Sarah has her hand up. Please introduce yourself.
Hi, my name is Sarah van den Broek. I'm a PhD in business and human rights from Leiden University. I have a question. I think it went to my mind from Claire's sayings, but it could apply to anyone, about the transposition, because you mentioned the importance of not really the text itself, but its interpretation and its implementation. And I feel that you're talking a lot about the business implementation, but there should also be probably some issues at the level of transposition. So could you a little bit elaborate on what you think the risks or the important points to to keep in mind at the transposition level, because now we had the fight. Well, let's take it for granted, but we had the fight at the European level. But now our job is also to recommend the transposition level, and I'm trying to do that right now in France. So it would be great to have some input from you on what to keep in mind, what's the important points, and maybe the national authority is one of them. So I'd like to hear your thoughts there. Thank you.
Do you want me to respond, or are we taking more questions?
Yeah, no, let's respond, because we do actually have some time. So
Okay, sure.
Yeah.
Well, thank you for your question, and you're absolutely right to raise it. The question. So first of all, there is that idea that I mentioned earlier about going beyond trying to just, by companies here, going beyond just trying to respect the letter of the text, but also trying to embrace the spirit of the text. And I think that's going to be key, and the spirit is the one that is in line with international standards. Now, you're very right to mention it's not only just about the transposition by businesses, and national authorities will have a key role to play. In fact, in the report for the French government that I mentioned earlier on the implementation of the French law, one of the suggestions that was made was to nominate a national authority in France to help clarify some of the uncertainties around the law and help interpret the law. So it's very clear that national authorities have a key role to play in the interpretation of the law, in guiding businesses, and in generally in its implementation. Now, my main worry is about the difference in fundings. And here I'll give you a very concrete example. If we look at the OECD national contact points, for instance, we see, for instance, the Dutch one is extremely active, extremely good. I assume it's very well funded and staffed. We can say similar things about the German ones, etc. The example I can give you is from my own first-hand experience here in Portugal. The national contact point, people working there are not even experts on business and human rights. They have a full-time job. They do that on the side. They've received one instance that they were created. It's just understaffed. It's just underfunded. And the outcome of that is very clear in the sort of activities that are being led. And so my worry is that we are going to see the same sort of issues and differences between various member states in terms of who the national authority is. Is it a new one that is created? Is it one existing one that is going to be given that task on top of its already busy tasks? And what are going to be their sort of financial support, because that does give an important that has important implications in terms of how helpful they're going to be. Then just to a last point to the sort of transposition of the directive. Of course, as for any other piece of European law, there's going to be the devil's in the detail. The translation is going to be potentially tricky, and I think there's going to be some questions. But I think there's one thing that is important to bear in mind, and it's clearly stated in the directive, is that it's a minimum standard. So member states can go further. It says that very clearly at the beginning of the directive. Member states can go further than that. So I think that in that sense is not a limitation on member states.
Thank you for this. I see two other questions. Let's try to keep it so that we don't go over too much. So maybe we'll take the two questions in a row, starting with Daria Palombo. Please, Daria. Nice to see you.
Hello, everyone, and thank you very much for this. It was absolutely needed. So I have actually two very different questions. One is very specific, and it's just what I thought by reading the directive. So I was wondering if anyone thought about this as well. And the other one is more broad. So I'll start with the broad one, which is in terms of third country impact. What do you think about the impact it will have in the United States? The reason for asking this is that I have read just comments from people at this stage that big US companies are very worried about the impact that it will have on them. And they are starting to change their code of conduct. And because the directive has an impact on big corporations, as we said, that could trigger a change in the whole, also in smaller companies, because usually big companies set somehow the standard in the US. So I'm wondering if anyone has also thought about this. And the other thing is very specific, and I have read the version of the directive from the 24th of January. I'm not sure if this is the last version, but what caught my mind immediately was the fact that if you look at the civil liability of company, which is Article 22, climate change is out somehow, in the sense there are articles on the due diligence in climate change, but it doesn't seem to me to be covered by civil liability. And I was wondering if any of you thought about this in terms of all these cases that there are new against Shell, against ING, etc., in terms of strategic litigation against corporations for climate change, and what's the impact is if climate change is not covered by civil liability in this directive. Thank you very much.
Thank you, Dalia. Maybe we'll take, so I think that these questions are perhaps more for Claire, but I will take Alexia's question. Very nice to see you, Alexia, former colleague at Wageningen Law.
So that's been part of the introduction. Actually, I'm now Policy Officer on Sustainable Supply Chains at the Belgian Ministry of Foreign Affairs in Development Cooperation. So my question is actually somewhat technical, but the version of the CSDDD that has been endorsed by the Council and the Iurii Committee of the European Parliament covers in the annex the right to just and favorable conditions of work, including living wage and living income for farmers and smallholders, interpreted in line with Articles 7 and 11 of the International Covenant on Economic and Social and Cultural Rights. And 7 pertains to decent work and employment conditions, and covers the right to just and favorable conditions of work. And Article 11 covers the right to an adequate standard of living. So, and companies will need to assess the impact created in their supply chains and then mitigate, including through revision of purchasing practices and investments into suppliers and the other measures listed in the directive. But could panelists share their legal analysis, what this provision actually requires of companies on the aspect of living income? First, and second, my question is in 2 parts, what the likely reaction of companies is going to be and what the impact may be on the ground. Thank you.
Thank you for this. And then Olia, I'll give you the floor for a very quick question, and then we'll have a round of all the speakers for final thoughts and trying to answer the questions. Thank you. Please.
Thank you, Nadia. Hi, everyone. My question is very quick. You might have covered it because I joined a bit late today. I want to ask what's happening with the directive and the national laws. Particularly, we were asked about what will happen, what will be the impact on the German supply chain law. Or can you just direct us to some information or place where we can find some information? Thank you.
Thank you for this. I think that connects to the question about transposition, because of course the context will depend whether there is a law or not. So maybe we'll go around to finish this off. I'll give the floor to Claire. Thank you. I think you had some.
So I'll take some of these points, and then I leave also some for my colleagues. So maybe on the question of civil liability, Dalia. So it's very interesting. In the very first version of the European Commission released in February 2022, I had access to the text a few days, like a leaked version, a few days before it was published, and there was nothing about climate change. And then the Article 15 was added at the very last minute as a sort of standalone. And it was very interesting because that last minute addition allowed for it to be completely disconnected to the civil liability provision. So there was clearly no civil liability for anything related to climate change. I'm not so sure this is true to the same extent now with that last version. Yes, there is a reference in Article 22 to Annex 1. There is a reference also to the articles on due diligence, Article 7 and 8. I think to the extent in which climate change can be said to have impacts on human rights, and of course this is more and more accepted, and then the right to a healthy, sustainable environment, it has been recognized as a human rights in and of itself. I believe we can and will be able to see some actions on the basis of climate change, but I think there is going to be that connection is going to be needed to be very clearly identified, and how this impacts, for instance, the health of people, etc. On the well, perhaps we can go around, then I'll check my notes for the other questions that I got lost in.
Thank you. Elisa, some thoughts on any questions you would like to answer?
No, just a reflection on the transposition. I think a lot has to do with the type of government that it's a very political policy. So I'm not sure where Europe is going. Let's see with the next parliamentary elections, EU Parliament elections, but I can see that the fierce opposition, and so the minimum requirement would be coming from perhaps right-wing populist dominated countries, which is also, somewhat worryingly a direction a lot of countries are taking. So I don't know. I mean, this is in terms of transposition. I think we will see a lot of differences depending on the type of governments. Ironically, we are going, these kind of directives are protecting citizens first and foremost, and their health and their very fundamental rights. And I don't think people have understood this. So voters have understood the significance that this directive could have on their own lives too. So I think this has completely come on our heads, and it has remained very, very confined into niche debates and intellectual areas or policymaking areas that people are not aware of what this directive could potentially, if it worked, imply for them. So
yeah, this is our role as academics also to make this, to bring this into societal debates. But I agree, it's been very technical and also left to lawyers largely, which I think is part of the same issue that we were talking about. Flaviano, thank you, Elisa. Flaviano, final thoughts?
Yeah, I mean, maybe just a thought to underline what Professor Giuliani just said. It's, I mean, it's this aspect of how those directives and regulation for the majority of the population seems very far away from them, and you can give easy ground to the populace to say that Europe is not really dealing with the real problem of the people. Like, I don't know, banning plastic bags at the supermarket, and people say, oh, this is against my, I mean, what is doing the EU dealing about the plastic bag in the supermarket instead of the real problems, and then they don't understand that plastic ended up in your food and at the end of the day in your body, and there are recent studies that found microplastic in the lungs of people. So so these regulations are important, and I think, again, I underline the fact that EU, in my opinion, should be the lead worldwide in this type of regulations. But it requires also a huge communication effort to make people understand that this is important to them. This regulation is not to undermine the power of European businesses and favorite China. This is to protect the health of European citizens, the health, their rights, the European citizens, the global environment, and possibly also the human rights and the health and all of the life of people in the supply chain. So even down the line. So yes, I think this is maybe, yeah, just the last remark.
Thank you so much, Flaviana. Thank you for participating. Olena, final words. I'm sorry we're over. I had a little bit of a senior moment with timekeeping here. I thought we had longer than we do, but please, Olena. And I think the fact that we're going over is also a testament of the interest in this directive. I think we are the first event. I'm sure there'll be many others going into many other issues, but I'm really grateful for your time. Thank you. Olena?
Yeah, my reflection is also that we need to go deeper to respond to many of questions that were raised. No, my general reflections about German supply chain law, that yeah, that the general expectations that it will reflect those provisions which directive requires to incorporate, but no, so German national authorities will need to analyze their law and just to identify what kind of provisions should be changed if they don't meet these minimum requirements. But if they are more strict, it's fine. No, so and it's about living wage. I don't want to go now in details because to be honest, I need to be more prepared to this kind of questions. But as I said, some companies already have such kind of practices, and of course it could be a collection of good practices or something. But the general approach that due diligence again is obligations of means, right? No, so the companies should provide those measures which again, which meet these expectations, but which are reasonably possible. So I think that this general approach should be applied to this standard as well.
Thank you so much. Thank you, everybody. Thank you to those who have stayed a little bit over time. It's been really a pleasure sharing this and hearing everybody's thoughts. Like I said, I'm sure there'll be many other events from very different perspectives. This is certainly not the final time that we talk about this. Thank you so much. And I encourage you to have a look at our Rebalance project website that I think was shared. Was it shared? If not, maybe someone can share it in the chat as I finish speaking. But thank you so much to our speakers, and I will see you very soon in other events. There you go. Thank you, Sana, for sharing. You could check out the project. Thank you so much. Bye-bye.